And hello to the people at home that can't be with us. This is AJ. We got my peeps with us, and we are looking at contract B for week 3, which is Estoppel. And I was just saying, hi all from Perth. Hi Tim. Good to have you with us. Tyler's saying she's enjoying it. Much easier to get your head around. Yes. Oh, look, misrepresentation is a very, very craggy area of law. And as I said, that's why I kind of take two separate runs at it. We do the first run in week 2. We try and get our head around some of it. And then we revisit it all again in, well, certainly the statutory form. We revisit that again in week 10. And it's amazing how your brain bubbles away and kind of sorts itself out between weeks 2 and week 10. When you come back to have a look at it later, I promise you it will be much easier to digest when you do a little bit of revision there in terms of statutory misleading or deceptive conduct. So that's why I kind of do it that way. But yes, Estoppel's a nice little discrete area of law, which is kind of friendly, kind of nice. The chapter's kind of short. And it's good because, you know, I've released the assignment, so people hopefully should be thinking about that, trying to cram in a little bit of extra reading in terms of the assignment. The assignment obviously is on duress and unconscionable conduct, so you may start reading ahead for those chapters. But that's where we are. I really like the whole intertwining of equity and contract. I know that you guys, most of you guys probably haven't done. Yeah, everyone's reading ahead. I like how there's some hope with the courts looking at equity. It's been 18 months since I did contracts, so I've had to do heaps of revision. Yes, I know. But thankfully, certainly if you did contract A 18 months ago, you know, there's not a whole lot of overlap. There is some because obviously you have to know what the fundamentals of contracting are. But really, for any assignment in contract B, I will assume that the knowledge that you get in contract A is already in your head, and I don't need to examine it. So the only things that I examine in contract B are stuff that we cover in this particular unit. So that's what I would say in relation to that. Don't stress about having done contract A ages ago, because there's not a whole lot of overlap, if you know what I mean. This is the fun bit, because this is where we get to see, you know.
No, I don't have to shout, Steve. I don't have money to do
Amelia, can I just get you to mute your mic? Actually, I'll mute it for you. There we go. And I'll mute Lena's as well. Okay, so we do, one thing I will say though, it's nice to kind of get a bit of a handle on the way that equity does overlap with contract. And don't be scared of equity. I guess Estoppel is where we kind of start, the whole equitable notions really start to come out more clearly in terms of contract law. And, you know, you don't need a full appreciation of equity in all its glory to appreciate the notion that you need to have fairness in contracting. And that's really what it's all about. You don't have to know all of the equitable maxims and stuff like that. We come across a few of them in contract, but where you need to know about them, I'll certainly, you know, flag those for your attention. But I do have that video. If people are starting to go, oh my gosh, I don't know enough about equity, I do have that video up online on Moodle for you that does give you a very brief and unsatisfactory introduction to equity. So you just kind of get your head around the basics and how it intersects with contract law. So if you want to have a look at that, it's up there for you. But this is where, you know, Estoppel is really where we start to see equity really flexing its collective muscle there. It was very helpful, that video. Yeah, it's just a bit of a primer. It's not intended anything, you know, anything more than that. But we really see how powerful equity can be in terms of getting a court to the conclusion that feels right. You know, it really is a weapon, and it's interesting. Do you recall in the text, you know, they started talking about equity being and the whole cause of the whole issue of promissory estoppel and being used as a shield, not a sword, and now it's being used as both a sword and a shield. Did you pick up on that? Yes, yeah, interesting, isn't it? Because normally the big thing is the equity follows the law. It's this kind of cowering cousin, if you will. And, you know, that's still true, but here is probably the best, estoppel is the best cause of action to see equity really leaping to the forefront here. Now, I do want to just make sure that you're understanding things correctly in terms of the development of the action of equitable estoppel, because what was the big worry with the development of this notion of promissory estoppel? I mean, it really marched onto the screen, didn't it, with Waltons and Marr? But why were courts so worried about introducing this notion of promissory estoppel in the way that they did in Waltons and Marr? What are you actually doing with an action for estoppel? You're enforcing a promise contract. Love it, Key. Yes. 10 brownie points. You're enforcing a contract with no consideration whatsoever. So having just said that contract A is irrelevant, I'm sure that you will remember that we do need to have consideration for any promise before a court will enforce it. And what the courts historically were worried about was, well, hang on a minute. Generally speaking, if there's been any estoppel that assists a party, it has always been confined to the context where the parties are already in an enforceable contract relationship. Okay, there's already been consideration provided. There's no question that we're going to open the floodgates to enforcing promises that haven't been sufficiently supported with consideration. And then all of a sudden, right up to Legion and Haitley, you know, if you read the case, the court's still very iffy and very careful about, you know, introducing the notion of promissory estoppel. And it was really only with Waltons and Marr that they kind of throw away the trainer wheels and say, okay, here we very clearly have a situation where there is no pre-existing contract between the parties. That's a given. But guess what? We're going to enforce its terms anyway. Also, wasn't there a worry about the parole evidence rule? Yes, I believe so. Because, well, explain yourself a bit more, Tyler. You can talk if you want. Turn your mic on if it's quicker.
I just remember reading something in the textbook in regards to like any pre-contractual agreements and like in the contracts, if you had something in regards to the whole contract agreements, whatever that's called, I can't remember, but that didn't necessarily prevent estoppel.
I can't remember that specific discussion. Hey, if you can find the snippet that you're talking about, post it to Moodle and let's have a discussion on that. But certainly, there is no contract. That's right. There's no contract in a Waltons and Marr scenario. There is no contract at all yet. All there is to that point was, you know, a reduction of terms to writing, but no signed contract. The beautiful thing about Waltons and Marr, though, it wasn't like there was just this vague promise that, you know, one party had said to the other, and then all of a sudden that party wants to hold them to it. There was a fully drafted contract. So if anything was going to get promissory estoppel onto the books, Waltons was the prime candidate, because it was a very nice segue from taking estoppel out of that context of just helping out one of the parties where the other party is trying to enforce the contract unreasonably, to the situation of there having been no pre-existing contract at all between the parties, even signed by one side and sent for exchange. Yes, that's right. So it was about as close as you can get to having a concluded deal as you can without actually having the concluded deal. And I think that's why the court was much more fortified in the way and robust in their discussion about promissory estoppel. It was all very tentative still in Legion and Haitley. So that's where it's all come from. And now all of a sudden we find ourselves in a scenario since the 80s where estoppel has been freed from that requirement to have a pre-existing contract, and it can be used as a sword as well as a shield. So by that I mean you can be a party that doesn't have a contract on foot, and you can try and still enforce a promise even though there's been no consideration provided, as long as you tick all the boxes. And therein lies the rub. Hey, so let us have a, let me just see, because I was going to recap the stuff here. All right, let me just share my document here. No, wait, I'm going to make you work for it. What are the 6 elements of promissory estoppel? Six elements.
The first one, that has to be representation.
Yes. There has to, hang on a second. The plaintiff assumed something. All right, I will share a document with you, and I'll tap it out, and then we can fill it all in. Let me share. Because I'm a sharing and caring kind of girl. There we go. All right. Now, can you see? Haha. Can you see my blank document? Yes. Let me just bring the chat box up here. Okay. Now, can you see the document? Yes?
Can see, but it's blank.
Yes, I know. So, what are the 6 elements from Waltons and Marr? In order to, and I think Brennan's judgment here, really, you can see he's being extraordinarily careful, knowing that they are freeing estoppel from this whole confine of trying to, having a pre-existing contractual relationship here. The first element is the plaintiff assumes.
Still blank, sorry.
Is it still blank now?
Yeah, but your typing sounds impressive.
So it's still, you can't see anything. Can I?
No, that's not right. We can see a blank document.
Nope. Really? It must be the actual internet here. All right, well, I will. What about if I try and share my other one? Stop sharing. I'll share my other one here. Here's something I prepared earlier. What about that one?
That one's got writing on it.
Ha-ha! We're away. Okay. So, you can see this one now? Okay. All right. So we'll go off this one. Plaintiff assumed a particular legal relationship existed or expected that one would exist between them. And the defendant in the latter case, the defendant would not be free to withdraw from the expected legal relationship. So they either think a particular legal relationship is already on foot or expected that one would be on foot. And if they expected that one would be on foot, that the defendant wouldn't be free to withdraw. Now, the text says something about that, doesn't it? What does the text say about this particular bit? Anyone have any ideas? No? That section of element 1 has been discussed in a number of other cases, and some judgments seem to indicate, oh, look at John, you've typed in the chat box like a champion. Assumed a particular legal relationship. B, that they induced the assumption. C, plaintiff acts or abstains in alliance. D, they knew or so intended. E, the action or inaction caused them detriment. And F, the defendant failed to act. Exactly. But that part that I bolded in the first rule has come under fire more recently, and the text does point out that there is a little bit of uncertainty as to whether or not that little rider that I've bolded there is still existent in terms of element 1. So the case facts from Waltons and Marr, what were they? Someone going to jump in?
The owner of a building was making a contract to demolish and rebuild, and prior to, he sent off he'd signed a copy and sent it off for them to sign, and after not hearing back from them has gone ahead and demolished and started the works, and then they tried to renege on the deal.
Yes. What was the really blatant part about Walton Store's conduct?
They knew that he had started demolition and works, and they told their lawyers to go slow and letting them know that they were reneging. So the unconscionable conduct.
Yes. The waft of naughty behaviour, sharp conduct, exactly. And it's exactly that conduct that enlivens equity's jurisdiction here. Okay, you must necessarily have a fairly clear case of the element, where are we? Here. Element 4, the defendant knew and intended the plaintiff to do so. Okay. And then stood by while there was some kind of harm or detriment. That is, those two elements will be the clincher for equity to then step in. So elements 4 and 5 are the elements that equity really needs in order to do the job. Okay, if there's no naughtiness, equity can't step in, and the ordinary rules of offer and acceptance and consideration will have to apply. So, but where you've got elements 4 and 5, you know, the court's prepared to say, hang on a minute, yeah, sure, offer acceptance consideration, but in this particular case, We think that this person should be held to this promise because of the naughtiness. Okay, why would Waltons want to occupy an old building rather than a new office? They didn't want to occupy an old building. They wanted to occupy a new office, and that's what the contract was all about. The contract was a lease for a new office that they wanted built to their specifications.
AJ, can you hear me?
Yes.
Yeah, I'd show my age, I suppose, but I remember around that time, for those that are a bit younger, Waltons was a big department store chain, a bit like Myer now, but they were quite successful and had big stores around Australia. But around about that time, they started to go bust. And I'm just trying to remember back, but that's a possible explanation as to why they decided to pull the plug on this deal, and mentions about restructuring. And yeah, I think that's probably around about that time.
Yes, I know. I'm kind of long in the tooth, and I recall having wandered around a Waltons store in Brisbane, in fact.
Yeah.
Although Myer seems to be going the same way, if you look at the papers, Myer's not doing too well at all. I think all the large department stores are kind of headed the same way. I mean, certainly online trading must have an impact on that. But yeah, I remember the old Waltons store in Brisbane. But that, yes, that was the sneakiness that was involved. They wanted a new office building built, and then all of a sudden things weren't going so well, and they said, go slow, we're not so sure we actually want this deal. Notwithstanding that they knew that poor old Mr. Marr was actually in the process of demolition. Not only demolition, I think 40% of the new building had been built. So 4 and 5 are the really important ones as far as equity is concerned. But number one is the element that the court will be really careful to ensure is satisfied, because unless you have a clear assumption that you've either got an existing legal relationship or you're going to have one on foot, then there's nothing sufficiently certain that can be enforced, okay? So just because you're enforcing something in equity under the rules of Estoppel doesn't mean that you can enforce any old vague promise, okay? It has to be very, very clear, and it has to be of a certain kind. That is, the plaintiff has to assume that it has legal ramifications, this promise. A legal relationship existed or was going to. And probably, I mean, there's certainly enough case law, despite the question that's been thrown out about that latter part of element 1. You may also have to show that the plaintiff thought that the defendant just couldn't back out. Okay, the defendant wasn't free to withdraw. So element 1 is kind of the comfort blanket that Estoppel throws out to make sure that the action in Estoppel doesn't degenerate into a court just enforcing any old thing because it's fair. Okay, you have to pay all due deference to the whole notion that you have to have consideration to enforce a promise. So unless it's going to be something that's sufficiently clear and of that type that element 1 requires, then you're not going to be able to enforce it. So that's the breakdown of the rules there. And that is the case we're going to need to discuss. Now, what the other case I want, Waltons led Marr on, yes, unconscionable, exactly. And that unconscionability, Tim, is what enlivens equity's jurisdiction, as we say. It allows equity to step in and say, nah, you know what, offer, acceptance, consideration, they're all highly overrated. Here, we have something clear that was promised, but there's been that naughtiness, so we can step in and we can actually say, well, despite the fact there's been no consideration or any concluded contract, we'll still enforce the promise. Now, a later case that I wanted to make sure that you understood was the Estoppel and Franklin's case. Inducement is always a part of contract negotiation. Inducement, yes, but there's generally speaking no problem with inducement. Where you are saying that something's true, you know, in order to get the other party to sign, pointing out the benefits of the deal, there's nothing wrong with that. Inducement is only an issue, really, where someone's, you know, trying to do something naughty and induce the party into the contract that way. Did that answer your question, Keith? I'm not quite sure whether it did.
I guess I'm looping back to the commercially naive question. I mean, there's no way as an investor that you'd ever start demolishing buildings and doing, you know, sinking huge dollars into a project, particularly with a conglomerate like Walton's, when you never sign contract.
Yeah. You'd probably have to read the case in full online to get an appreciation of why that happened. In that case, poor old Mr. Ma really did want this job terribly badly. And obviously where you're a little guy and you're trying to get a big guy on board, you know, you'll bend and flex and try and get the deal across the line. Particularly Walton's was kind of playing him even from a fairly early stage, because at the beginning they were saying, you know, hurry up, hurry up, hurry up. We need to have this store open. We want all this work done quickly. These are the milestones. These are the dates. You know, snap to it. Snap to it. And when they're the party with the commercial might, I can understand why Mr. Ma caved in, particularly because they had represented to him that the contract was pretty much over the line. They said, here's the contract. You know, if we want any amendments, we'll send them through in the next couple of days. So he waited the couple of days and thought, that actually, well, they mustn't want any amendments. So he, you know, given that there was time pressure, that's why, I mean, the clause had a counterparts provision. So he signed his counterpart, sent it through to them, and he just expected that it was a formality, basically, that they would send the counterpart back.
I guess that's the issue. He just expected. That was based around his expectations, which may or may not have been validly formed. There's all sorts of tests, but there is no test for commercial credibility. Where do you draw the line between, and we're about to get onto it with Estoppel, where both of those guys were really, really, really professional negotiators and have been in the business forever. So there was a different standard applied.
Yes.
But where's the test for the standard? In this case, it just looks to me like this guy was completely naive.
But just because a party is naive, I mean, if they have been clearly led on by the other party, and bear in mind that he was dealing with their solicitors, so he was expecting that this was all above board. And I guess, you know, notwithstanding that he might have been a bit naive, if the reasonable person would conclude that they were going to have a contract on foot within the next day or two once he'd got his signed counterpart, you know, they effectively have put him in the position in terms of time pressure and negotiation pressure that he made the decisions he did. I don't think you can say equity's not going to step in because you're stupid.
Why not? I mean, if you've got stuff in, you know, I'm going to contracts A here, where you're not supposed to, a court won't step in and say stupidity.
But it's not just a case of stupidity, though, is it, Keith? You've got stupidity on the one, if you want to call it stupidity. I wouldn't call it stupidity. I would call it being placed in a commercial position where he was either, you know, in or out. He had to move quickly if he was going to make this contract work or not.
So he had the choice. And he made the call. He made the decision that he was going to demolish the building. He was going to do all this stuff in advance of having a piece of paper in his hand that said, yeah, we commit. They hadn't committed.
Okay, and then what do you say about Walton's then deliberately saying go slow? We know that he expects this counterpart. We know he expects that all of this to happen, but go slow. Let him do all of this stuff and we just won't say anything. So do you think that the law should just leave that alone?
But that's a negotiating tactic. I mean, you speed up or you slow down negotiations as it suits you, not the other party. And as far as dealing with a solicitor's like a real estate agent. They're there to protect their client. They're not there to do the right thing by the other side.
They are there to make representations on behalf of their client and conclude a deal if they are able to do so. I don't see. Okay, take your argument to its logical conclusion, Keith. So you think that any scenario like this of sharp dealing where the other party is taking advantage of a party that they've basically led to believe that a certain state of affairs would exist, you think that they should just be able to go through ahead with that and that equity shouldn't step in at all? Is that your position?
Unfortunately, no. I get the fairness issue. I don't know where the line is. I don't know where the line is in between the Marr case, who in my view was commercially naive, and the Estoppel case, where they were equals punching it out.
Well, okay, perhaps we need to go back and revise the first step, and that is the plaintiff has to assume that a particular legal relationship existed or expected that one would exist, okay? Now, if you're going to be relying, as Mr. Marr did, on an expectation that a legal relationship would exist, then you need, if it's clearly unreasonable that you expect a legal relationship to arise in the circumstances, then who put the rush on the bill? It was Walton's store.
No, they didn't put a rush on a bill. What they did was they built a time frame.
Yes.
I mean, whenever you buy a house, the agent will always say to you, oh, no, there's another party interested. You have to sign up by this afternoon, or they're going to come in tomorrow and they'll sign up 9 a.m. in the morning.
And
it's not a real deadline. It's a negotiating tactic. This is negotiating. This is not, I mean, yeah, this is not real.
Negotiation in an atmosphere of pressure that was deliberately designed to induce an expectation that a contractual relationship existed. Now, if you've got a quibble with that, I think, you know, we're going to have to move the tune along, Keith.
Yeah, sure. Sorry, I didn't mean to figure out
forever. But what I will say before we leave the point is, and if other people want to jump in, please let me know. How would Marr know that? He was worried he would move it. Yeah. They said hurry, then said slow down. Yes. So there was a bit of shilly-shallying, wasn't there? But I think that the comfort you're seeking, Keith, is the fact that the test that we use for element 1 is an objective test, and it requires that a reasonable person in that plaintiff's shoes would have thought that would be the case. Does that give you the comfort you need? So a reasonable person in Mr. Marr's shoes would have expected that that legal relationship was going to arise. Where they don't, where equitable estoppel will not succeed, is where the expectation was unreasonable.
Yeah, I guess I don't see that.
Okay, so he may have been stupid, but if that's the case, the reasonable person would have similarly been stupid. And that reasonable person is the person that we use as our test in contract law. If Marr didn't litigate against Waltons, they could have just walked away. Yes, because they didn't have a concluded deal.
Yeah, thanks. Sorry, I didn't mean to divert too far. But
that's okay. As I said, I'm happy to debate the point. But the reasonable person test in conjunction with element 1 will, I think, provide you with the comfort that you're after in terms of not helping out idiots. Okay. If they are silly, then similarly, the reasonable person would have been silly. And if that's the case, then you're going to get some relief.
A moron on a slow day?
Sorry? A moron in a hurry. Estoppel and Franklin's, can we quickly just, oh my word, the time has gone by. Estoppel and Franklin's was a case of negotiation between, as Keith said, two far more commercially powerful parties, so very experienced on both sides. There was a little bit of sharp dealing by the party that was trying to enforce the estoppel. And there particularly was no agreement in relation to some extra space that Franklins were hoping to lease. And what did they do about that? Instead of confronting the issue squarely, they just left the issue silent and hoped that it wouldn't be raised so that they would get a cheaper price on the rent overall. 2 of the 3 said that Franklins could not raise the estoppel, and they gave the lease to another party. So that's another useful case in terms of this particular tutorial problem. What I will do now is I will go to our tube problem, and I will go down to week 3, and let's just very briefly look at, this is it.
Hi Felicity, come on in. How's uni going?
Not too bad. Always busy though. I'm studying contracts this semester and I can't get my head around it. The lecturer is a pompous ass, which doesn't help.
You know, my contracts lecturer was like that too. Maybe it comes with the job. Are you here to see me about contracts?
Actually, strangely enough, I am. But it's not about my contracts course. I have a contract issue.
Ooh.
And I just don't know enough to handle it myself.
Well, hopefully I can help them. What's the issue?
Last summer break I spent the whole time working. You name it, I did it. Basically worked my fingers to the bone all summer so that when I got to uni I wouldn't have to work too much through the semester. Know what I mean?
That's pretty sensible. Did you make much?
I made a packet. Just after uni started again, though, I was having a cup of coffee with a guy named Ron. He's an old school friend. A good guy. Most of the time. Anyway, Ron has just opened a pizza joint and he was looking for delivery drivers. So he suggested that I use the money I'd saved to buy a car, then work as a delivery driver for him.
What did you think of that idea?
I wasn't sure. On the one hand, it would be kind of like an investment, turning the summer money into a steady source of income. It would also mean mainly working in the evenings, so my weekdays would be free for uni. But it was also kind of the opposite of what I had intended, because the whole idea was that I wouldn't have to work during semester. I told Ron this, and he said I should think it over, but if I wanted a job with him, I should go buy a car. In the end, that's what I did.
Okay, how did that work out?
It didn't even get started. Once I had the car, I contacted Ron and told him I was ready to start work, and he apologized and told me he had given the job to his cousin Steve. So now I'm stuck with a car I don't need, no money, and no job. I can't sell the car, but there's no way I'll get back what I paid for it. I've been screwed over. I have a feeling there should be something I can do about it, but I'm not sure what.
Did the 2 of you ever have a written agreement about the work you would be performing?
No, it's not like that.
But the idea for purchasing the car, that came entirely from him.
Yes, I have no need for a car other than doing this work. I've hardly driven the thing since I got it.
Okay, Felicity, pull out your textbooks. Let's see what we can come up with together.
Okay. So, how do we go there? Did we hear the, yes? Okay, so let me just share my document again. All right. They were discussing plans. She tells him about the money she earned with summer jobs. He suggests that she use the money. She tells him on the one hand she considers it would be like an investment. But on the other hand, she says it's the opposite of what she really wants, which is not to work during semester and leave her time free for study. She says that she'd think it over. But if she wanted a job, she'd buy, he said, to think it over. But if she wanted a job, to buy a car. We're not told how much time elapsed between this statement about think it over, but if you want a job, you should buy a car, and then her actually buying the car. She says, once I had the car, I contacted Ron, told him I was ready to start. He then says he's given the job to someone else. She feels screwed over. She complains if she sells a car, she won't get all her money back. Okay. In relation to element 1. Now, if I scroll down, peeps, can you see me scrolling at all if I'm scrolling? Oh, good. Okay. So going back to element 1, the plaintiff has to assume that a particular legal relationship existed or expected one would exist. If you're in the category of expecting that one would exist, then you may or may not also have to show that you thought that the defendant couldn't withdraw. Okay. What do we think about that element in light of the facts that we've been given? Does she expect that a legal relationship did exist or that one would exist? Don't mix business and friendship. Sorry, I just got Tim's post there in the chat box.
Yeah, so would exist, being an employer-employee relationship.
Yes. So if you follow the Brennan scenario, then she needs to show that she expected a particular relationship would exist and that Ron couldn't back out. Okay. What do we think about that? Okay. Don't all answer at once. I've got my point of view.
I think she clearly did, because if she didn't, she wouldn't have bought the car. But I suppose it would be dependent on, looking at your notes as well, the other factors that we're not aware of, so the time that's passed and how formal that conversation was and how it was left.
Yes. My problem with element 1 is that it does need to be a clear expectation of a particular legal relationship. So here, where are we? You're absolutely right in that, Felicity. I think Keith said something like this as well in the chat box. Believed that an employment relationship would exist. However, what were the terms and conditions of that contract that she's trying to enforce? Let's get to the nitty-gritty.
If she purchased a vehicle, he would give her a job.
That's the nature of would exist if she bought a car. What I'm trying to get you to do, Diane, is tell me what the terms and conditions of her employment contract would be that she's trying to enforce.
They weren't discussed.
Sarah's saying, was there a contract? And I would agree. Tyler says he was making a suggestion. He never said she would get the job.
Mm.
Let's go back and have a little look at what I wrote down when I was trying to type what they were talking about. She said she was mulling it over in her mind, wasn't she? Because she was saying, yes, it'd be good. You know, there would be a steady income. The work would be at night. But then she also said to him, hang on a minute, it's kind of the opposite of what I want, really. you know, because I'm then going to have to work during semester. I don't really want to do that. So it certainly doesn't seem like she's, do you know what I mean? It doesn't say, he doesn't say, I will give you, you know, 15 hours per week at $12.65 per hour for at least the next, you know, 6 months if you go and buy a car, did he? It wasn't that clear, is my point. She's shilly-shallying around. He simply said if you wanted to do it, yeah, not that she would get the job. That's right. There was no offer and acceptance. But Sarah, we don't have to think in terms of offer and acceptance in this formal sense. All that we need to be able to show is that the plaintiff had formed this assumption. Okay, so don't wander into offer and acceptance. But I see where you're going in terms of there just wasn't the clarity here. There wasn't something that we can isolate that was enforceable in terms of an employment contract, was there? Yes, it was her thought process. She was kind of all over the shop, really, wasn't she? In a way, if you know what I mean, in the nicest possible sense. Too ambitious. She certainly feels like she was induced by the car. But what we have to prove for element 1 is that she had a clear expectation of a legal relationship. And this is where it's not like the Waltons and Marr scenario, is it? Because in Waltons and Marr, they had all the terms and conditions written out, agreed, right there, as Sarah said. You know, it was almost like, here's your offer, here's your acceptance, bingo. This is all very up in the air. And in fact, she said that, you know, he says to her, think it over. Now, is that the language of I am now offering you a job?
Yeah, that's what I picked up on, AJ, that bit there, that she, think it over. It seems that almost there's a step missing in her process, in that once she's thought it over and she decides to go out and buy the car, she really should have rung back and said, or contacted him and said, look, I've thought it over and I think I will take you up on that offer or you know, that proposal, and I'm about to go and buy a car.
Yes, exactly. And that's my point also in terms of, well, how long was it before she actually does decide? We don't know. I mean, if it was the next day, maybe it's a little bit more arguable, but if she's left it, you know, a week or more, well, surely you're right. You'd think she would have clarified the nature of the relationship that she was going to assume would be at the end of this deal if she bought the car.
Yeah.
The other thing that bothered me, and I don't think I put it down there, but I'll put it here. Now, the lawyer says, did you have an agreement? And she says, no, it's not like that. So remember that they were just friends. So query whether she actually expected a legal relationship at all, or whether he was just going to throw her a few bucks on the side. In any event, I think that you would have problems with step 1. My IRAC goes a bit like this. Here. It's unlike Walton's because the terms of the legal relationship were not agreed. We don't know whether Felicity would have accepted the hours or the working conditions or the pay. None of the essential, sorry, I'm looking over at the chat box now. Should have told the ATO could be listening. The facts, none of the essential terms were agreed. Facts here are also unlike Ostotel because there was just one main term there that wasn't agreed. Okay, here everything's not agreed. There's no price agreed. There's no, you know, number of minimum hours per week agreed. You know, we don't know what perks she was looking for in terms of, you know, was there any, you know, packaging that she'd do. There was none. There was no detail there. Nevertheless, in that case, Priestley said proprietary estoppel could be established even if the plaintiff was unable to point to precise terms describing what they expected. Okay, but there you only had one main term that was missing. Okay, here like I said, you've kind of got everything missing. She didn't buy the car for any other reason that she didn't want a car. She wouldn't have bought the car. Yes, but Shona, can you see I'm still stuck on point 1? We haven't. You're talking about inducement there, and we're currently still stuck on point 1, which is, was there a legal relationship that she expected? And I have a problem with that. I actually think she'd probably fall down on element 1.
Maybe Keith's comments about stupidity before are more relevant to this case, and that although she obviously thought one thing, that the reasonable person in her position probably wouldn't have.
Possibly, but again, what we need to, yes, the reason here, I think, would say, you know, was there an actual legal relationship I expect? What, if I'm going to try and enforce it, what are the terms of that? There are none. You know, I think you'd probably fall down. Even taking the broadest view, Priestley's view from Estoppel, and saying, okay, she just assumed that she'd get a contract of employment. He induced her. She bought the car in reliance on the assumption for element 3. He intended her to do so. She'll suffer detriment. He hasn't acted to stop it. Even there are going to be problems in terms of element 1, because you've got this rider to element 1 that she has to not only expect a legal relationship, but that he wouldn't be free to back out. And I think that that would cause her problems as well, so far as element 1 is concerned. And here you'd bring in the case of Dame Kiri Tukanua, where it was held that a promoter expecting Kiri to enter a contract for concerts couldn't establish an expectation that she would not be free to withdraw. The parties were still negotiating. Okay, I think that's a little bit more like what our scenario is here. Don't read your IRAC. I will now. What relief is she looking for? She wants to actually have the job. Or compensation for the loss on the sale of the car. Yes, well, either I think she'd probably be happy with. But she says, you know, it's really no good. I think what she wanted really was the job, because she says, if I sell the car, I'm not going to get enough back. I guess you could say, well, if we could get you the compensation for the shortfall. End of the day, what are the damages? She could be dismissed on some form of notice. Ah, Keith, you picked up on a point I was hoping someone would pick up on. And I want to segue to that. Can we just bookmark that for a minute? Because I want to come back to that at the very end, because I think that's the icing on my argument. Say that she got up on element 1, which I don't think we would, particularly on Estoppel. I think there's too many discussions between, too many points in this discussion which indicate that nothing really had been set in stone. But anyway, I think she'd be having trouble with this rider that she thought Ron wasn't free to withdraw. Assuming she could get over all of that. There was obviously inducement, which everyone has been telling me in the chat box. Element 3, she definitely relied on the discussion to purchase the vehicle. Element 4, I have problems with also, because I don't feel that Ron stood by, in the sense that there was that conduct in Walton's. You know, you've got to have that clear waft of naughtiness to enliven equity's jurisdiction. And as far as poor old Ron's concerned, she hasn't changed her mind. She hasn't bought the car. He doesn't know. And he certainly hasn't stood by and watched her suffer this detriment. I don't think in the same way as they did in Walton's. In terms of element 5, I think there would be detriment. That's my highlighted bit there. However, she is left with a car. So is that really material disadvantage? Well, I'm unsure. There might be a bit of a shortfall. Is that a material disadvantage if she has to sell at a slight shortfall? I don't know. It's certainly not the 40% complete new building that there was in Walton's.
Wasn't she a uni student?
She was a uni student.
Yeah, well, having a car as a uni student is a definite disadvantage, isn't it?
Yes, exactly. Well, she does say she catches the train and stuff, so I guess she doesn't really need it. So I'm not sure. If I was Ron, I'd be saying that there's no material disadvantage. Element 6 is fulfilled, obviously, because he hasn't done anything to stop it. My problem, I think my biggest problem would be element 1 with her, and the fact that there was no concluded terms of an arrangement there, that she could expect a legal relationship to arise and that he couldn't back out of it. If she could, taking the broadest view of Priestley's discussion in Estoppel, then it seems like Ron would need to provide her with employment. That would certainly accord with the approach in Gemelli, but a court will never actually enforce an agreement like an employment agreement where they'd have to be constantly playing the policeman between the parties and trying to sort their arguments out. He does tell her if she buys a car, she can work for him. Yes, he does. You can't let that go. Build a bridge. Yeah, I know. And this is where, as lawyers, you've really got to, you need to advise your clients very level-headedly. And if you think that even though it feels like they've been, like she says, screwed over, you have to look at the law very dispassionately and weigh up their rights very clearly for the client. Because if you were, unless Felicity wanted to run off to QCAT and argue her case in court there, you know, just as a self-represented person with very minimal cost, if she was actually going to take this thing to court, man, you know, it would cost, well, the average litigation will cost you about 150 grand. So unless she has a rich auntie, it's just not worth, you know, contemplating an action like this for the want of, I don't know, however much less the car's going to be worth, which may not even be a material disadvantage so far as equitable estoppel is concerned. Or certainly, you know, in terms of the employment relationship, a court's not going to order specific performance of that because of this authority here. JC Williamson and Lukey Mulholland. We'll discuss that case when we discuss remedies at the back end of term. I'm just flagging it for you here. A court just wouldn't step in. So you need to be able to tell, you know, your client, look, I understand you might have suffered, you know, maybe a $5,000 loss on selling the car if that's what you're going to do. But if you want to take this to court, it's going to cost you a lot more. So is there some arrangement that you can come to that doesn't involve, you know, litigating this matter in court? I think you'd probably be pushing it uphill. Cheeky letter of demand. You possibly could. Again, John, that I guess you'd have to advise the client, we can write you a letter of demand, although if you value the relationship moving forward, is a letter of demand something you really want to resort to? You might want to be saying to the client, you know, look, can you go back to Ron and say, look, I have bought this car. What can we do about it? Because, you know, if we're friends, you know, I felt that I had the job. What's the story? You know, just approach it on a a social level rather than a legal level. He said, it's yours if you buy the car. No friendship left now. I'm with Shona. So, Shona, I come back to what was the nature of the legal relationship, and that's what she would have to prove. And that's where Estoppel stands in the way, I think, because there wasn't sufficient detail. Okay. Yeah, I understand your explanation. This is why I say sometimes it's hard to give clients the advice they don't really want to hear or that you feel is right. But you've got to do your job in a fairly even-handed fashion. Does anyone feel that she does have? Can anybody put an argument to me that overcomes my problem with there being this lack of detail? Complete lack of detail. Someone please prove me wrong if you can, because if we can get her the result that she wants. Only the rent. Read my IRAC. I'll post Shona's IRAC for everyone. No! Everyone wants to see it now, Shona. Can you see? I just have an issue with it. But anyway, if someone thinks of a bright idea as to how we can show that she actually has this well-considered employment relationship that she can enforce, I don't know. Felicity could lease her car to Ron as a delivery vehicle. Maybe. She could try and work for Uber Eats. Okay, I hope that that's satisfied your concerns, at least if not alleviated your sense of injustice. We can have a brief mics off. If you want to leave, I'll stop sharing now. I'll pop that up online as I do normally anyway. But if you've got to run, then please run. If you want to stay for 2 minutes and shoot the breeze with me, make extra comments, that's fine. I'll stop the recording now. Bye to the peeps at home. I will see you next time. And